So this video is all about the Nitwit's guide to working with an estate planning attorney. A lot of people come into the office. A lot of people go into another attorney's office and say something like to the attorney, I don't even know enough about what questions to ask. I just know I need to do something. Or maybe at its most basic level, that prospective client of the attorney will walk in and they'll have a sheet of paper and they'll have a list of things that they think they need. And that list is usually 4 items long. They looked up estate planning on the internet and found some article that said that they need 4 things: a will, a financial power of attorney, some kind of healthcare directive, and a living will. So they walk in and they say they need that. But that's so shallow. And to me, it's like, going to somebody who's going to build your home and say, okay, Mr. Builder, I need you to build my home and I need brick, flooring, and stucco. Well, really, really basic. So really, I want to go a little further than that and give you a heads up as to what that meeting, what that conversation, what those questions and answers, what all of that should sound like in the first meeting with an estate planning attorney. Because really that first meeting is you got to get it right. You got one shot at, and this is I'd say it's over your entire lifetime and you're passing away. This is the single largest financial thing that you'll ever do is leaving your estate the right way or protecting it while you're alive. So it's so important. Got to get it right the first time. Okay, so I want to talk about I'll start first with what the basics of that conversation with an attorney should sound like. And then we'll just take it to a little bit of an advanced level. Not much, not real high end, but just the very basics. And then what if you went a little bit beyond that? All right, so I'll start with the fact that, and let me get this one out of the way. This is a pet peeve of mine, and this is not pertaining to just the beginning part of the conversation. This has to do with the entire conversation. But in general, I want to get this point behind us, that if the attorney talks too much, if the attorney talks in a way that it's over your head and you don't understand anything that they're saying, kind of like the old Charlie Brown cartoons where there was somebody on that cartoon, I don't remember the details, but whenever he would speak, it would go wah 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 wah. If that's what you're hearing from the attorney, then you got the wrong attorney. And then this whole part about them talking too much, and I guess it's lawyers like to talk, and they went to law school because they were good speakers and arguers, and lawyers are supposedly excellent speakers. But really the more important skill when you do meet with that estate planning attorney for the first time is the more important skill, at least 2 skills that are more important than them speaking, and just telling you what to do, is first listening and then asking questions. So if you're looking across that table from the attorney, you might want to notice that it's more than likely that the attorney has 2 ears and 1 mouth. And what goes in either one of those ways and out this way ought to be in about, proportion. So maybe the attorney's listening 2/3 of the time and speaking 1/3 of the time, because it is impossible for an estate attorney to customize anything for you and your family without them asking lots of questions and listening closely to your responses so they can ask you the next right question. Okay, so that's just a general theme throughout. Now let's get into some of the basics and then a little more from there. So really at the beginning, and I know most lawyers don't do this, but at the beginning, it's just common sense. They should ask you, Mr. So-and-so, Mrs. So-and-so, is there anything in particular you want to make sure that we talk about as we have this conversation about protecting what you have and making sure it passes along, the way you'd want it to? And so, that's a real important question. Most lawyers don't ask it, but again, the idea here is the lawyer's role is to really pull out of you what is most important. And maybe if you are a nitwit, as the title of our video describes, maybe if you heard that question, you might say, I don't even know what to ask. I just know I need to do something. I heard everybody needs to have an estate plan, so I'm here and I got nothing. Or maybe there is something in particular that you do want to address, and so you can mention that to the attorney. And quite frankly, if you just listen and watch the rest of this video, it may prompt you to have some things in your back pocket that you can reveal that are important to you. So sometimes, when that client comes in and says, I ain't got nothing, I don't really know enough about it, then I'll sometimes give them that, I call it a buffet of things that many people do bring up when they do have something, and we ask them that, what's on your mind, or what do you want to make sure you talk about or accomplish as part of this conversation. So, sometimes when we ask that initial question, some people say, well, Paul, we just want to make it simple for each other, for our kids, or we want to make sure our stuff goes to the right people, or we want to put the right people in charge of our estate when we die, or we want the right people making our medical decisions if we can. We want the right people handling our money if we get to a point where we're not able to sign our name and deal with our accounts. Or some people say we want to protect what we have if we get sick and need long-term care. I hear we have to, we lose everything if we get sick. We'd like to protect it for our family. Some people say, this one or more particular heirs of ours, they can't handle money, so we want to talk about how it can be properly handled for them. And some people say we want to make sure our estate is set up to pay as little tax as possible. So it could be any one of those things. And so sometimes when I say, well, here's some issues that some people tell us that they come in to talk about, and sometimes that triggers a response. So if it does trigger a response, or quite frankly, if the lawyer doesn't ask you that question, what's most important to you, shame on them, but you really need to be able to be prepared to tell them what is most important to you. And hopefully, at a minimum, they will listen to that and perhaps ask you questions about what is most important to you, rather than them going into some long discussion about your will or your trust or whatever it is that they're trying to pigeonhole you into. Okay, so here's the basics that initial conversation should at least cover, that you should be prepared to have a conversation about. And it's really some obvious stuff. One is who gets the things that you leave behind. And so there's probably you should expect to have a conversation about, if you have children, do you want to leave everything that you have to your children equally? If it's not equally, do you want to leave things in percentages? Not common, but not uncommon. Do you want to leave things to grandchildren in addition to your children? Do you need to leave any specific asset, like the home, to a particular person with the balance going equally or in percentages of others? Where, again, those specific bequests, not the majority, but many people have reasons to do that, and all that's okay. So in addition to who's going to get your stuff, you should be prepared to answer the question, who's going to be in charge of making sure when you die that your instructions are followed. And so many people say, oh, you mean the executor? And it might be executor, it might be trustee, depends on the mechanics and what you use. But yeah, and so now there's oftentimes a discussion about, do you name one of your children to do that? Do you name all of them? Do you not want to offend a certain child or children by naming others? So expect to have that conversation. In the basics, you're going to have a conversation about, if you get sick and you're not able to talk to your doctors, go get your medical records and bring them to the whatever. then who do you want being able to handle all of those medical decisions for you if you're in a condition where you can't make your own medical decisions? Maybe you're in a surgery. And again, when we have that conversation, if you're married, most people appoint their spouse, maybe an adult child or children as backups, but that's a conversation to have. Likewise, who's going to handle your money if you get to a point later in life, at some point during the rest of your lifetime, where you're not able to sign your name and deal with your accounts? Who do you want being able to do that for you? Who should the backup be? So expect to have that conversation. And if you're a married couple going through this together, a real important discussion that needs to be part of every married couple having an estate planning discussion is, when the first spouse dies, how does that first spouse to die want to leave what they have to their surviving spouse? There's options there. There's just, I leave my spouse ownership of everything, which is simple, but there's no protection for the children when the first spouse to die leaves ownership to their surviving spouse. The surviving spouse then could change things, either because they want to or they're influenced to later in life. So some married couples like arranging what they have in a way so that when they pass away, they leave things perhaps in trust for their spouse so that their surviving spouse can get the benefits from all of that. But when the surviving spouse dies, the first spouse to die's part must come back to the heirs of the first spouse to die. In Louisiana, we have a usufruct arrangement, which is similar to a trust arrangement like that. So every married couple discussion ought to have, that how do we leave things to each other? And then I would say also in the very basics is do any of our heirs, do any of my heirs need to have their inheritance managed for them? Because they can't handle money, they're getting government assistance for other reasons, they're minors, they're young. So that, I would say, is part of the basic discussion. I read a will that an attorney drafted a few months ago where grandparents left 1/3 of their estate to be divided equally among their grandchildren. Some of the grandchildren were 2 years old. That's really just a complete nightmare if the grandparents die and minor grandchildren inherit in their own name. Way too much court involvement there. If you're leaving things to minors, it ought to be in a trust for them to eliminate all of the court supervision of the inheritance until they're 18, and then it's dumped in their lap. So, those are the basics that you should expect to discuss when you have that conversation with an estate attorney trying to get things in order. And then if we just take it to the little bit next level, because I hate to leave it at just the very basics, because some people need more than just the very basics. So as we take that estate planning conversation to the next level, there's likely to be some questions and answers and some discussion. Perhaps if you're a kind of middle class person, about protecting what you have in case you get sick, need long-term care, and how to perhaps avoid losing everything to nursing home expenses. So that's at maybe that next little level. Perhaps at that next little level, there's a discussion about avoiding tax. And there's lots of different kinds of tax associated with estate planning and passing along what you have to the next generation. Most families don't have to deal with the estate tax because there's an $11.58 million exemption. So as long as when one dies, they have less than that amount, there's no 40% estate tax. But nonetheless, there are significant capital gains tax consequences with the step up in basis. Want to make sure you get all of that right. And there's some income tax consequences, maybe with your IRAs, and especially with the new Secure Act, which there may not be anything your estate planning attorney can do about, but there are estate tax, capital gains tax, income tax, sometimes property tax considerations that go into the structuring of an overall estate planning program and how to keep as much as you can of as much of what you worked for in the family. And then again, as we go to that next little level, there's typically a conversation because not every family is normal. In fact, 29 years, I don't think I've seen a normal family yet. And so in way more families than I thought, there's a real necessary discussion about making the children's inheritance, I'm going to call it divorce proof. Children either have been divorced, they're married to someone that parents don't want that son-in-law or daughter-in-law having control over the inheritance. Maybe the children might get divorced after they inherit. And perhaps there should be some discussion about how to make sure that those past, present, or future ex-spouses of your children never have any control or say so over your money. And then again, every estate planning discussion, I can't imagine having one without at least having it brought up about the whole, should you leave your estate to your heirs through your will or through a revocable living trust? And that could be a kind of state by state issue, and quite frankly could be an attorney by attorney issue. On one far end of the spectrum are the attorneys who say everyone should have a trust because everyone should avoid probate. And then on the other end of the spectrum, there's the attorneys that say no one should have a trust, or virtually no one. Everyone should have a will. Leave what you have in your name. The probate process will take care of it when you die. And so I feel like in the appropriate estate planning conversation, inform, educate, and then let that informed client make the decision that they feel is best for themselves, their spouses, their family, their survivors. So that needs to be part of the discussion. So I got another point that's really, really important as well, but I did want to summarize before I go to that next really important point. And before I summarize and then go to the next really important point, I do want to encourage you to hit the subscribe button. In fact, slam the subscribe button, and might as well ring that dang notification bell that pops up as well. That way you don't miss anything. And then thumbs ups are awesome as well. All right, so summary is, basics. Be prepared to, if asked or not even if asked, tell that attorney what's most important to you. If you got something that's most important to you. If you can't think of anything, the attorney probably ought to provide you with a laundry list of typically what things are important to people when they put their estate planning program in order. And then be prepared to talk about what happens to your stuff when you pass away, who's going to be handling that when you pass away, who's going to be talking to your doctors on your behalf, who's going to be dealing with all of your accounts if at some point during the rest of your lifetime you can't do it for yourself. I didn't mention it, but I'll mention it now, that life support machines decision. So that's all part of the basics. And then at the next level, we get into things like, does the money need to be managed for the heirs? Do you need to have a discussion about protecting it if you go into a nursing home? What are the best ways to avoid, minimize, or eliminate taxes, whether that's estate tax, capital gains tax, income tax, or other tax? Does the children's inheritance, do we need to take an extra step to make sure that it stays protected from their past, present, or future divorces? Is avoiding probate worth what you'd need to go through to get that probate, that avoidance of the court-supervised and attorney-involved probate process when you die? Now, what I find sometimes, particularly when maybe and no offense to financial advisors, there's some amazing financial advisors out there, but it seems like when there's other third parties in the room, like their financial advisor, stuff gets brought up that gets over talked about. One of those things that kind of drives me a little bit batty, and it may not make sense to you, is when somebody suggests, well, Paul, shouldn't we discuss, what happens if, before, the clients die, all their children die, all the children's spouses die, all the grandchildren die, and all of their siblings die. We ought to address what happens, if there's that apocalypse. And I'm not saying it shouldn't be addressed, but I am saying let's discuss the reasonable things that are likely to happen first, and let's get all that addressed before we talk about some of these, very remote contingencies. We got to get the basics and then a little bit beyond basics first before we talk about the apocalypse. Because quite frankly, I've been doing this now for 29 years and kind of knock on wood, I've never been involved in an apocalypse situation. Not to say it's not going to happen, but sometimes when the wrong people are in the room, things can get brought up that overcomplicate the matter, particularly if you have a client who is a nitwit, and I'm not trying to offend people, but particularly if you have a potential estate planning person who's just kind of hanging on because they're not going to understand things if things get beyond that kind of basic level. And if we start talking about the apocalypse and it gets complicated, they're just going to shut down. So that's a scenario I see that a third party in the room might bring up, and I just kind of say, oh boy, I really don't want to go there because I really want to hit the normal stuff first. But anyway, that's it there. And so last point is real important. Make sure 10 a.m. Central Time every morning, tune in more estate planning educational videos where I will add to my repertoire of 360 something videos that I have on YouTube so that you can be better prepared to have better discussions and do a better job protecting what you have for yourself and for your loved ones, and hopefully making it a little bit easier and giving you a little more peace of mind and not so much stress as you go through this process and maintain things throughout your lifetime. Okay, we'll see you tomorrow.